Now let's proceed to the UN Convention on Contracts for International Sales of Goods, or CISG. The CISG was drafted by the United Nations Commission on International Trade Law, or UNCITRAL, and adopted in Vienna in 1980. So it is a multilateral treaty, which is an agreement between several countries, and that establishes a uniform framework for governing international sales contract of goods. So unlike as a bilateral treaty, which only involves two countries, the CISG is open to multiple countries to join and become bound by its provision. So the CISG becomes binding for the contracting parties involved in the international sales of goods, as long as the countries for both parties have ratified or adopted to the CISG. So contracting parties is initially ang mga uh, parties nga na-belong sa country nga nag-ratify or nag-adopt sa provision sang CISG. So, but the contracting parties can also choose not to be bound by the CISG. So, it is according sa Article 6 sang CISG, which allows the party to completely exclude the application of the CISG by specifying to their contract, and it also allows the country or the party to derogate or excluded from the specific provision of the CISG, which means ang CISG is not completely excluded, but parties can choose not to apply specific articles or sections of the CISG while being subject to the rest of the provision. So parties should also specify in their contract which articles or sections they wish to exclude. So CISG was based on the two previous attempts to achieve uniform law and international sales, such as the Convention relating respectively to the Uniform Law of Formation Contracts for the International Sales, or ULF, which governs the formation of international sales contract. Next is the Uniform Law on the International Sales of Good, or ULIS, which deals with the rights and duties of the parties in the international sales contract. So both were adopted in The Hague in 1964. However, it did not gain a widespread success, and the main reason is that only a few states took part in drafting these uniform conventions, and their provision were criticized by many socialists, by many countries, for not taking into account the interests of many socialist and developing countries. So the UNCITRAL, which was formed in 1966, determined that these two conventions were not sufficient. So the commission revised them, where they put together these two conventions in the new draft. And in 1980, the UNCITRAL final draft of CISG was approved, and CISG entered into force on January 1, 1988. So the CISG has now gained a worldwide acceptance, and it is considered to be the most successful convention promoting international commerce. So, UNCITRAL reported that 77 states has adopted to the CISG. But as of October 26, 2023, there are 97 states that have adopted to the CISG. The CISG contains a 101 articles, and it is divided into four parts. So part 1 is about the rules on its application and general provisions. Part 2 is about the formation of contract. Part 3 is it contains the substantive rules for sales contract, which indicates the obligations and rights and the remedies of the parties. Part 4 is about the rules on ratification and entry into force, including the reservation. In continuation, the reservations are significant in order to determine whether a state has ratified or adopted to the CISG. So when a country ratifies to the CISG, it essentially means that they agreed to be bound by the convention's rules on the international sales contract. However, countries can also take reservation on the specific articles within the CISG. So it's like saying na we agree to the CISG in general, but we will follow a particular rule. So without checking the reservation, it might be assumed that CISG applies to the entirety of the contract when in fact there is irrelevant provision that were not applied. So there are options that may be taken by the ratifying states and they fall into three main categories. First is the reservation which may prohibit the application of the CISG, the reservation that may limit the application of the CISG, and the reservation that alter the content of the CISG. In terms of the reservation, which may prohibit the application of the CISG, these prohibitions may be reflected to such reservation under Article 93, Article 94, and Article 1, sub paragraph 1p. So under Article 93, CISG may not extend to all territories of the federal state. So this allows the federal state to limit the application of the CISG to specific territories within their jurisdiction, so within their federation. So for example, there are a lot of territories within US, such as the California, New York, New Jersey, Hawaii, Michigan, and many other states. So US is allowed to limit the application of the CISG where, for example, applicable lang yung CISG sa California, New York, and it is not extended to other territories. So this is because many federal states may have varying legal system, which they might prefer the CISG to only apply in a specific region with a strong focus on international trade. So generally, CISG applies to international sales contract between parties whose place of business are in the countries that have ratified or adopted to the CISG. However, there is an exemption, okay? Under Article 94, two or more countries that have ratified to the CISG can mutually agree for the CISG not to apply in their specific trade relationship. So this agreement has to be reciprocal, so meaning both countries need to consent. Under Article 1, subparagraph 1b, this allows the application of the of this article, um, meaning even if the private international law directs towards the law of a contracting state, which it is a legal system that allows the application of CISG, if a country has made a reservation or formally declared to not adopt CISG, then CISG wouldn't be applied. Next is the reservation that may limit the application of the CISG. So it is where either Part 2, which is about the formation of international sales contract, or Part 3, which is about the substantive rules defining the obligations and duties of the parties and remedies of the CISG, is excluded. So for example, both parties will apply the articles of the CISG but excluding the content in terms of the formation of contract. So it means that some certain contents in their contract are governed by the CISG, but in terms lang sa formation of contract, they exclude CISG provisions about it and applied the governing law they agreed upon. Lastly is the reservation that alters the content of the CISG. So this reservation means of pulling out specific provisions in which a country is effectively altering the way the specific provisions of the CISG applies within its jurisdiction. So the standard CISG rules are no longer in effect for those reserved articles. So for example, in Article 8 of the CISG, which is about the formation of contract. So this article deals with the offers and acceptance rules for forming a contract. So a country might have a reservation on this article, indicating that they prefer their own domestic rules to govern offer and acceptance in international sales contract. Moving forward, so these are the main contents of the CISG. So there are five of them. First is the criteria for identifying an international sales contract according to the CISG. Next is the scope of the CISG's application. Next is the formation of international sales contract. Also, the buyers and sellers' obligations, and of course, the remedies for breach of international sales contract. In terms for the criterion for identifying an international sales contract, according to Article 1 of the CISG, the place of business of the parties to contract is the only criteria for identifying an international sales contract. So under Article 1, subparagraph 1A, a contract is considered as an international sales contract if the parties to the contract have their respective place of business in a different countries which are a contracting state. For example, sabi si seller is nakalocate ang iya business sa US while si buyer naman is sa UK. Next, under Article 1, sa paragraph 1B, or the rules of private international law, leads to the law of a contracting state. So private international law provides a set of rules and principles that helps the court to determine the applicable law. So private international law often relies on connecting factor like the party's place of business to determine the applicable law. Now again, if ang place of business sang both parties is from different states or countries na nag-ratify or nag-adapt sa provisions ng CISG as the governing law in terms of their international sales, then the applicable law would be CISG. Note that neither the nationality of the parties, kung American man siya, Pinoy, or Japanese, okay, nor the civil or commercial character of the parties, like kung ang iya bala pagbakal or pagbaligya sang goods is for personal consumption or business consumption, these are not used as an indicator to determine if the sales contract is may ara sang international nature. Next is the scope of the CISG's application. So there are two cases of application where CISG applies. So first is if may ara sang choice of law na naga-refer sang application sang CISG. Second is if the applicable law is not expressly or impliedly gin-identify sang party sa ilang nga contract, the CISG at this event will be applied under Article 1, subparagraph 1A and B, in which in subparagraph 1A, if wala sang private international law na mag-apply, then the CISG would be the governing law, in which in subparagraph 1B, the private international law is gonna refer ang laws of contracting state, then the applicable law would be the CISG. But not all contracting states automatically applies the CISG in terms of their sales contract. So the CISG upholds the principle of party autonomy. So this means that the parties involved in the international sales contract have a significant freedom to choose the law that will govern their contract. And even if both parties are from the CISG contracting state, they can agree to in their contract to exclude CISG and choose another body of law. So there are three cases of non-application. So the first one is the non-application of the CISG to a certain types of transactions, such as the consumer sales, auctions, executions, or other sales by authority of law, and the sales of securities. So in terms of the consumer sales, CISG focuses on the commercial transactions and not on the personal or household use. In terms naman sa auctions, auctions have a unique rules and procedures specific to auction houses. So CISG avoids interfering with this established practices. In terms naman sa sales of execution or authority of law, national laws governs these sales, and CISG doesn't want to override or overrule these laws. And in terms naman sa securities, such as ang mga shares, stocks, or investment securities, so these are governed by the specific financial regulations. Next is the non-application of the CISG to a certain specific goods, such as the ships, aircrafts, electricity, and property. So the sales of this certain transportation, such as the ships and aircrafts, have a complex registration and regulatory process which CISG avoids dealing with such complexities. In terms naman sa electricity, it is often treated differently than tangible goods due to its unique delivery and regulatory framework. So also, CISG primarily focus on facilitating international trade in tangible and movable goods. And electricity is intangible. In terms naman sa property, regardless that it is tangible, it is still immovable and cannot be physically delivered. Lastly, is the non-application of the CISG to some subject matter, such as the validity of the contract, the effect which the contract may have on the property and the goods sold, and the liability of the seller for the injuries caused by the goods to any person. So this is determined by the domestic law in the country of one of the parties agreed by both of them. So we have here the table that shows the CISG applicability. So we have here the forum or the forum states, which refers to the state whose court system will handle any disputes arising from the contract. So when we say naman reservation contracting state, again, it is the country that has ratified or officially adopts CISG, but with reservation or not binding to one or more specific articles of the CISG. So when we say naman non-reservation contracting states, hindi naman siya ang country na nag-ratify or ga-adopt sa provisions ng CISG but without any reservation to any articles of the CISG. So this means they fully accept and are bound by all the articles of the CISG. While ang non-contracting states naman is a country nga hindi bound or officially adopts ang provisions ng CISG. So their domestic laws will typically governs the international sales contract involving their business. So here, if if the reservation contracting state is the forum state and where the applicable legal system is the law of the reservation contracting state, the CISG may not be fully applicable. So this reservation limits the full application of the CISG within their legal system. So this means that the domestic law of the reserving contracting state will generally prevails over the reserved CISG articles, and this allows contracting states to exempt themselves from applying specific articles of the CISG in their contract. So, next naman is if since ang non-reservation contracting states is wala siya any reservation to any of the articles of the CISG, then the full CISG potentially applies to the entire contract. So now kung ang iya law is ang mag-prevail or will be the applicable legal system na CISG obviously will be applicable not only to its certain not only the certain articles of the CISG but all of its articles. So regardless if ang forum state is the reservation contracting state. So next, if ang non-reservation contracting state is ang forum state and the forum has an international law obligation to apply CISG, then the full CISG would be applicable regardless if whether ang applicable legal system is ang law of the reservation contracting state. So this is because the obligation to apply the full CISG prevails over any other limitations imposed by another state's reservation when the forum states is from the states that is bound by the full CISG, it is bound by the full CISG without any reservation. So the law of the reservation contracting states do not hold power over this specific situation. But if applying CISG does not constitute to a correct application of the lex causae or law of the case, then CISG will not be applicable. So the first option is an exemption or it is only applicable regardless if the law of the reservation contracting state is the applicable legal system since it is the specific situation where the application of the CISG is being imposed or it is binding to the forum state. Now, if it is not the given situation and if the CISG will still be applied, where supposedly the intended applicable legal system is the law of the reservation contracting states, then it can cause uncertainty and complexities which can result to disputes. And lastly is the if the forum state is the non-contracting state and its applicable legal system is the law of the reservation contracting state, the applicability of the CISG is not possible. So the fact that they haven't formally um, adopts or haven't formally agreed to be bound by the CISG provision, and also given that their applicable legal system doesn't render them to apply CISG, their courts are not obligated. Then their courts are not obligated to apply it. So, in the absence of the CISG, the court of the non-contracting states will apply their own national or domestic laws to resolve any disputes that arise from the international sales contract. Now let us proceed to the formation of international sales contract. So this includes the offer from the seller or offerer and the acceptance from the offeree or buyer. So the first is the offer. So the offer needs to be specific and leaves no room for doubt about what's being offered. So the person making the offer or the offerer needs to be genuinely intend to be legally bound by the agreement once his or her offer will be accepted, because it is not just a casual suggestion. So the offer must also be directed to a particular person or a group of people, or what we call the offeree. So a general advertisement in which it announces nga may ara sang sale sa ila product wouldn't necessarily means uh, wouldn't necessarily considered an offer, but an email to a specific client with a quoted price of the product would be considered as an offer. But in some cases, if the person making the proposal doesn't address it to the specific individuals, but clearly indicates their intention to be bound, then it is considered as a genuine offer. So examples in it is ang clothing brand which launched a limited edition collection of sneakers which they display a poster outside their store with a detailed information about the shoes, and it is also stated in the poster the phrase about first come first serve, limited to 100 pairs. So here the limited quantity demonstrate the seller's intention to be bound by a contract with the first 100 buyers who completes the purchase process. So while it is not addressed to the specific individuals, so anyone who goes to that store can become an offeree by attempting to purchase the sneakers before they sell out. So next, under Article 15, subparagraph 2 of the CISG, ang point diri is that the withdrawal of offer can happen even for irrevocable offers, but only bago or at the same time makaabot ang offer kay offeree. Now, if nakaabot una ang kay offeree ang offer bago pa ang withdrawal ni offerer, revocation or cancellation of offer can happen, but only valid lang if nakaabot kay offeree ang revocation bago pa niya masend ang acceptance kay offerer. Note that both the withdrawal and revocation needs to be communicated to the offeree in order for it to be effective. So next, after the offer, the acceptance is what is expected to consider in order to form a contract. So an acceptance is an indication nga gin-accept ni offeree ang offer. So nag-agree siya sa tanan nga terms and conditions nga gin-propose ni offerer. So the offeree's indication of assent can be expressed through various means, including oral communication through saying yes or verbally agreeing to the offer, or through written communication such as sending written acceptance letter, email, or other documents. And as soon as this indication of assent reaches the offerer, the acceptance becomes effective and the contract is formed. So there is a meeting of minds. So aside from the indication of assent of the offeree, which is explicitly communicated to the offerer, such as the verbal communication and the written communication. So the indication of assent can also consider implied acceptance. So this means offer, the offeree can demonstrate their agreement to the offer through actions, even without explicitly communicating their assent in words. For example, some actions that may constitute an implied acceptance includes dispatching goods, which if the offeree starts delivering the goods requested in the offer, this could be interpreted as accepting the offer. And also, if the offeree um, pays for the goods, and uh, this describes as it can be seen as they are accepting the terms of the offer. So in addition, the CISG does not consider silence or inaction on the part of the offerer, in the part of the offeree as acceptance. So wala na diri apply ang silence means yes. So this means simply not responding to the offer, even if the offeree receives it, does not create a contract. So a contract requires a meeting of minds. So if both par meaning both parties must willingly agree to the same terms. So in continuation, an acceptance is considered late if it arrives after the time stipulated in the offer, or after the reasonable time has passed since the offer was received. So the offerer has two options regarding to late acceptance. It is either nga i-accept niya or i-reject ang late acceptance. So in addition, acceptance with modification or changes in the original offer is generally considered or generally called as counter offer if the changes are material or significant in size. For instance, proposing a lower price, a higher quantity, or a different delivery time frames. So both parties can reject or accept counter offer, and the contract will form after they will reach the agreement. Now let us proceed to the obligations of the buyer and the seller. So both parties are legally bound sa kung ano man ang ilang nga agreehan sa ilang nga contract. So the buyer does have to perform their obligations under the contract, the CISG, the usages and practices they agreed upon between themselves. So according to the CISG, the buyer and the seller are under the following main obligations. So in terms of the obligations of the seller, okay, first, the seller must deliver the goods that conforms and are free from third-party rights. So if the place of delivery is not explicitly stated in the contract, the seller must in principle make the goods available at the place where he has a place of business. The seller should also deliver the goods on the exact date that was explicitly stated in the contract. Now, if the contract may not give an exact date, but gives an implied time frame, like for example, a contract might say delivery within 2 weeks. So in that case, the seller must deliver the goods within that implied time frame. So if the contract is silent on both the specific date and in any time frame for the delivery, then the principle of reasonableness applies. So this means that the delivery should occur within the time frame that is considered as fair, and proper under the circumstances of the contract. So, for example, Abby, in terms of the types of goods, so custom made or complex items would likely to have a longer, reasonable delivery time compared to the readily available stock items. So if the goods naman needs to be manufactured, the time that the goods will be completed will be the factor. And also the location of the buyer and the complexity of the shipping logistics would also be considered. So furthermore, the seller has a primary obligations to deliver the goods that conforms to the agreed upon specification or standards in the contract. So the goods must conform, or uh, the conformity of the goods means that the goods must be on the quality must be on quality, quantity, and the description required by the contract. So additionally, the seller must ensure that the goods are free from any third party rights that could interfere with the buyer's ownership and the use of goods. So, this means that no one else can come forward and say that they have a right or claim to the goods sold. So, for example, sinisang third party rights are the goods that are used as collateral with unpaid taxes or stolen. So if the buyer discovers a potential legal claim against the goods, they are obligated to inform the seller within the reasonable time. And if the claims are significant enough, the buyer may be able to cancel the contract and get a full refund. But there's an exemption to this rule in which unless kung nagpasugot man niya si buyer to purchase the goods regardless if it is subject to third party claims. Next, the seller must also hand over any documents relating to the deliver delivery of, or in terms of the delivered goods. So these documents might include the certificate of origin, the bills of lading, the invoices, the warranty documents or compliance documents. Next is the obligations of the buyer. So the buyer must take the delivery of the goods. So the buyer has an obligation to accept and deliver and take the delivery of the goods. And once the seller fulfills their obligations under the contract, so in principle the risk passes upon taking the delivery of goods. So now if the buyer does not take the delivery, he or she would breach the contract, which makes him or her liable for any damages to the goods. And of course, the buyer must pay for the agreed upon price for the goods to the seller according to the terms of the contract. So the payment is the main obligation of the buyer. So the obligations to pay covers four elements such as the determination of the price, which refers how the price of the goods is established, the place of payment, the moment of payment, which refers to the specific time when the payment is due from the buyer, the methods of payment, like for example through bank transfer, letter of credit, or cash on delivery or COD. So these elements are usually agreed upon in the contract. So if the sales contract doesn't explicitly state the specific details about the payment, the CISG provides a supplementary rules. So the CISG dictates that the buyer must pay the seller at one of the two locations in case of the absence of a specific agreement. So it could be at the seller's place of business or the place where the goods or the documents related to the goods are physically transferred to the buyer. So the CISG also establishes that the buyer's obligation to pay arises as soon as they take control of the goods or documents, and there is no need for further notice from the seller in order to trigger the payment obligation. So lastly is the remedies for the breach of international sales contract. So in the process of implementing international sales contract, if the breach of contract is committed by the breaching party, the other party can apply the agreed remedies in the contract or laid down in the CISG. So according to Article 79, subparagraph 1 of the CISG, it states that breach of contract includes all forms of defective performance, like for example, abe, delivering goods that are damaged or do not meet the agreed upon specification. And of course, breach of contract especially includes a complete failure of the parties to perform their obligations. So it includes both excusable and inexcusable non-performance. So when we say excusable non-performance, this refers to the situation where a party is not held liable for a breach due to unforeseen event beyond their control that renders the performance impossible. Whereas ang inexcusable non-performance naman, it refers where a party fails to perform their obligations without valid excuse. So this lead to the full liability for this leads to a full liability for the breaching party. So in addition, for the choice of remedy, it is also important to know if there is so-called fundamental breach of contract. So it has two elements. So the first is there has to be a substantial detriment which deprives the aggrieved party of what he or she is entitled to expect under the contract. So the harm caused by the breach must be more than just a minor or trivial. For example, the substantial detriment could include the financial loss, missed opportunities, or defective or unusable goods. And of course, the result of breach must be foreseeable. So this means that the breach must be predictable and could be reasonably anticipated to occur. In continuation, the CISG provides an equal remedies for both the buyer and the seller, such as to require performance of the obligation, fix an additional period for the performance, declare the contract avoided, and claims for the damages. So, in terms of the remedies for the buyer, they can require specific performance, which this allows the buyer to insist the seller to fulfill their contractual obligations exactly as agreed upon. So this might involve demanding for a specific goods that meet the agreed upon specifications. So the buyer may also fix an additional period for performance, which it grants the seller an extension of time to fulfill their obligations. So in terms of the remedies naman for the seller, they can also require specific performance from the buyer. So this might involve demanding that the buyer makes an agreed upon payment or take the delivery of goods if they have refused to do so. So same with the buyer, the seller can also fix additional periods for the performance where it grants naman the buyer an extension of time to fulfill their obligations. Now, if it becomes clear nga either sa parties is wala naging pag-asa nga i-fulfill ang ilang obligations, then the aggrieved party may suspend or rescind the contract. So, like for example, abi, ginotify ni buyer or ni seller nga hindi nila pag i-fulfill ang ilang expected obligations, or it could be the non-performance is lampas na sa extension time nga gin-grant. So, the aggrieved party can claim damages against the breaching party. So, the amount of damages is gadepend siya kung it is determined by the size of the loss, including the loss of profits or ang dapat tani kitaon ni seller if nabaligya niya ang goods or ni buyer if nabato niya ang goods. So there is an exemption of the breach. So this means that the buyer or the seller is not liable for the failure to perform if it is due to an impediment beyond his control rendering the performance impossible. So the impediment is what we understand as force majeure. So examples of force majeure or events which is beyond the control of a person includes the natural disasters such as the earthquakes, floods, or hurricanes. It could be acts of war or terrorism, government regulations or prohibitions, or the pandemic. So this exception is only valid until wala pa na-resolve ang impediment.